Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today is Memorial Day, a national holiday where citizens remember those who served in the military dating back to the Independence War, who made the ultimate sacrifice in the name of the liberties that we enjoy that are set forth in our nation's founding documents, the Constitution of the United States. One of the items set forth therein requires due process of law whenever the government is seeking to take away someone's life, liberty, or property. And one of the key elements of due process is the right to a fair and impartial jury and judge. There are some who feel that Mr. Kohberger, although he pled guilty in open court last year, did not have a bona fide opportunity for an unbiased jury trial, and that may have played into his decision to plead guilty and to change his strategy enormously, which was until that time that he would be going to trial and would challenge the state of Idaho's contention that he was the sole and the correct defendant responsible for the catastrophic events at 1122 King Road in this capital case at the beyond a reasonable doubt evidentiary standard. Mr. Kohberger pled guilty to the charges that were brought against him instead of standing trial, and 4 of the sentences involved life in prison without the possibility of parole. And he signed appellate waivers, meaning he gave up the right to appeal his sentence and anything that happened at the trial court level. There is a potential, however, for Mr. Kohberger to challenge his sentence. Now, he's given no indication at all as of this date that he intends to do so in the form of an appeal. However, there is a case that is before the United States Supreme Court right now, and it is called Hunter versus United States, that may change the law on appeal waivers. SCOTUS has been called upon to revisit its landmark case of Garza versus Idaho, which was specifically referenced by Judge Hippler last July after Mr. Kohberger changed his plea. In Garza, the Supreme Court found that an appeal waiver like the one that Mr. Kohberger signed is not a 100% ironclad barrier against all appeals. There are exceptions, but those exceptions are few. What the Supreme Court has said in Hunter versus United States is that this court has recognized that no appeal waiver serves as an absolute bar to all appellate claims. And then citing to Garza, saying, but the court has made no statement on what particular exceptions to appeal waivers may be required. What has happened since Garza is that the federal appellate courts have interpreted that decision in different ways. There's a split as to what the appellate courts believe that SCOTUS meant in Garza. And so therefore, the Supreme Court has said that the 2 questions presented to them in Hunter are, number 1, whether the only permissible exceptions to a general appeal waiver are for claims of ineffective assistance of counsel, or that the sentence exceeds the statutory minimum. And the second question being whether an appeal waiver applies when the sentencing judge advises the defendant that he has a right to appeal and the government does not object. At this time, we are on docket watch, awaiting a ruling by SCOTUS if there will be additional grounds for a defendant who signs away all appellate rights like Mr. Kohberger did to possibly appeal on other grounds, such as deprivation of due process. Please stay tuned to the Indie Zone, and as soon as a decision is reached by SCOTUS, we will, of course, advise you. Until next time, thank you for for joining us here today.